Tonight, police use of a leaf blower and red Solo cups to collect evidence called into question.
The same kind of Solo cups that we all see at backyard barbecues.
Yep, they hold liquid terrifically.
How one responding officer is defending their actions, plus one of the first paramedics on scene when John O'Keefe was found in the snow, takes the stand.
I asked if there had been any significant trauma that happened that preceded this, and she answered with a series of statements that she repeated. I hit him. I hit him.
And questions about closeness.
That is true. And you asked me if I knew her, and I said yes. And you asked me if I'm friends with her, and I said I wouldn't say friends.
More on the fiery exchange over a connection to the family that owned 34 Fairview Road. Canton Confidential, the Karen Reed murder trial, starts right now.
Week 3 of Karen Reed's second murder trial kicked off with a full day of testimony. There were many faces on the stand today. Good evening, everyone. Thanks for joining us. I'm J.C. Monahan.
And I'm Glenn Jones. There were a literal handful of witnesses questioned, and that was before lunch. And afterwards, a retired Canton police lieutenant went on record after he says he used a leaf blower and plastic party cups at the crime scene. Let's get out to NBC 10's Melody Mendez. She joins us live outside Norfolk Superior Court to catch us up on what happened today. Melody.
Well, Glenn and JC, it was a busy day. There's a lot to unpack. The day started with a forensic scientist, and it ended with red Solo cups and a grocery store bag. Take a look. Karen Reed had a blood alcohol level above the legal limit the morning after John O'Keefe's body was found. It was 0.093%, according to a forensic scientist who was first on the stand in day 9 of her retrial. Ryan Nagel was up next. He was a passenger in his own pickup truck when they drove to pick up his sister from a party at 34 Fairview around midnight, January 28th. He said he pulled up in front of the home behind a black SUV. He saw a woman inside, but no man. Nagel's ex-girlfriend, Heather Maxson, another passenger, testified that she saw a man in the passenger seat before, but later did not. Next, Sarah Levinson, a friend of Brian Albert's son, who was inside 34 Fairview celebrating his birthday, describing the night as joyful and celebratory. She left the home around 1:30 a.m., getting a ride home from Jennifer and Matt McCabe. Levinson was asked if she noticed anything unusual on her way out of the home that night, like a man laying right in the yard, saying no, but that she'd been looking down at her feet so she didn't slip on the snow. During cross, Alan Jackson also mentioned that in all the years she'd been friends with Brian Albert, she had never met the family dog.
You had never met their dog, had you?
Their dog?
Their dog.
I'm not completely sure.
Didn't you testify about a year ago in another proceeding that although you had been to the Albert home many times, you had never actually met the dog?
If that's what it says I said, then yes.
Reed's attorneys have argued that injuries on O'Keefe's arm were not caused by an SUV, but instead by Brian Albert's dog, Chloe. Jackson also mentioning how Levinson was not interviewed by police until 9 months after John's body was found. Canton firefighter paramedic Katie McLaughlin was next on the stand, testifying that in the moments after she responded to 34 Fairview, where John's body was found, Karen Reed said the words, "I hit him," 4 times. McLaughlin was also asked about her relationship with the daughter of the homeowner, Brian Albert. During the first trial, defense attorneys accused McLaughlin of perjury after she testified that she and Caitlin Albert were not friends, but photos emerged showing the two in a number of social situations and on group trips together. Last on the stand, retired Canton Police Lieutenant Paul Gallagher. Gallagher responded to the scene the morning of the 29th and faced intense questioning about how he handled evidence in the case, like using a leaf blower and Solo cups and a Stop and Shop bag to collect evidence, actions he defended.
I thought a leaf blower would be the best method because I have seen it used and to remove light layers of snow.
Did the leaf blower work as you had hoped?
It was great.
As for the use of Solo cups to collect blood,
The same kind of Solo cups that we all see at backyard barbecues.
Yep, they hold liquid terrifically.
They're also not sealed. Canton PD has evidence collection bags at Canton PD.
Yes.
You also know that they have materials and tools to gather biological material, correct?
We do have swabs, yes.
If you're a mile from the Canton PD,
Yeah.
you could have gone back and done a swab.
Could have.
But you didn't.
Didn't want to because of the weather.
So retired Lieutenant Gallagher will be back on the stand tomorrow, where Alan Jackson is expected to continue cross, and we will, of course, be here live for it all. Reporting in Jeddah, Melody Mendez, NBC 10 Boston.
Mel, thank you. Our chief legal analyst, Michael Coyne, is back with us tonight, and we also like to introduce criminal defense attorney Neil Fagel. Welcome to Canton Confidential.
Thank you for having me.
All right, we want to begin with a closer look at the testimony of Paul Gallagher. Here's more of his answer on why a leaf blower was used to collect evidence.
Why didn't you use a shovel at that point?
I was afraid I would miss something or possibly break something. I thought a leaf blower would be the best method because I have seen it used and to remove light layers of snow, and it can be controlled.
There was also mention of a Stop and Shop brown paper bag for holding evidence and the use of red Solo cups as well.
And what was the purpose of using the red Solo cups?
They were plastic. They weren't going to leak. They weren't going to get soggy. They were large. I needed a small sample.
All right, Neil, we're going to go right to you with the first question. This is the difference between trial 1 and trial 2, right? The first time we heard red Solo cups and leaf blowers, I think it's safe to say we all went,
what?
Right. This time around, listening to the former lieutenant, it's like, well, yeah, Solo cups do hold liquid pretty well. And if you didn't have anything in your car, now it's starting to make sense. But I'm asking you as a defense attorney, should Jackson have gone harder so that I'm not walking away thinking, well, that was reasonable?
JC, I think looking at this from a trial attorney perspective, absolutely. In 30 years, I've never seen red Solo cups introduced in a case as holding a liquid. And Attorney Jackson has to point out all the negatives that the police have done. And this, in my mind, rose to the level of some shoddy investigation and follow-up. It's not the way you want to preserve evidence.
To JC's point, if you're sitting on the jury, you have your own layman understanding of what is reasonable. This does not seem reasonable. Did he explain it enough to convince somebody otherwise?
I thought he explained it about as well as anyone in law enforcement could explain it. To me, today, he's one of the stronger law enforcement witnesses we've seen. Now, in the land of the blind, the one-eyed man is king. And the law enforcement up to now has not covered themselves in glory, as we've talked about before. So he was a strong witness, and he's likely going to stay that strong and not cave to Jackson's pressure. But I think what you're going to see, as Neil points out, is there will be more aggressiveness with respect to the visual image of the red Solo cups alone. In and of itself, we don't have to be told that blood shouldn't be collected and maintained in there. The jury will see that image over and over. We saw the leaf blower today. Well, I think the defense will continue to hammer away that this is a sloppy collection and preservation of evidence.
And yet the explanation was very clean. I mean, given that you had another bite at the apple, it was very well explained. Driving in a blizzard, using my own car, I didn't have any resources when the moment came. It was clear to me. The prosecution called 3 people who were in or at the house the night before John O'Keefe was found. All of them told a similar story. Nothing stood out to them that night. There were no problems at 34 Fairview Road. They all said they saw Karen Reed's car in front of the house around 12:30, 12:45 that night, and they said they never saw anyone go into the house at that time. So, Michael and Neil, did the prosecution make any headway with these witnesses? Did the defense do anything to question whether or not they remember things correctly?
I think the prosecution did a nice job in trying to establish that no one went into the house. They showed it from 3 separate witnesses, 2 from outside and 1 that was inside the house. So they clearly, I believe, established that John O'Keefe did not leave or walk across the front yard, go up the driveway into the house.
But where is he?
They weren't perfect about when they talked about Karen Reed's car being out front. Some said that maybe someone was standing outside the car. Others said they couldn't tell if someone was in the passenger seat.
That is the problem with these witnesses, is that they gave both sides something to work with, right? That no one puts them inside the house, but no one says that they saw the body there or they saw him exit the vehicle. And so both the defense and the prosecution have something to work with. I think where the defense has to be much more careful is, to me, they're trying the same case they tried last time, and while the witnesses might have the same names, they are not the same witnesses. They are far better prepared. They stick to what the information is. They're making their key points. So the prosecution is getting a lot to work with here that we didn't see last time, and these witnesses stood up well.
Agree.
All right, let's circle back to the testimony we heard from Canton firefighter and paramedic Katie McLaughlin. She's a key witness from Reed's first trial, recounting she heard the defendant repeat the infamous line, "I hit him," many times.
I asked if there had been any significant trauma that happened that preceded this, and she answered with a series of statements that she repeated. I hit him. I hit him. There was a woman next to us who told her to calm down, stop talking, calm down, you're hysterical. So she repeated, I hit him, and a police officer asked her, said, you what? And she repeated it again, I hit him.
McLaughlin is such an interesting witness because she went from first responder to having her personal life and friendships probed in ways perhaps she never imagined. Of course, McLaughlin grew up in the same town as Caitlin Albert, whose family lived in the home where O'Keefe's body was found in the snow. But she has maintained they are not close, and she rejects the defense suggestion that she might conspire over a story to make Karen Reed look bad. There was a contentious moment when Jackson confronted Katie about a group photo where she and Caitlin were both seen.
I was invited to a baby shower, not Caitlin Albert's, but she was also invited to the baby shower.
Right, and the two of you posed for a photograph together, correct?
We posed around the girl that was having the baby.
Right, you and who else?
A bunch of other girls, her friends.
Right, was one of them Caitlin Albert?
She was in the photo, yeah.
Standing right next to you in the photo?
She could have been.
Can I approach her?
No.
Oh, we're going to talk about that approach question in a moment. But Neil, I wanted to ask you about the cross of this witness, because I certainly understand the point you made earlier about the cross on Lieutenant Gallagher. That is about potential not proper conduct while conducting an investigation. But this is a paramedic who seems to have a personal life kind of turned upside down. Would you use the same level of aggression here?
I think that's his job. He's a criminal defense attorney. He has to poke holes in a case in any way he can. She arrived on the scene. She wasn't even a paramedic when she arrived. She came in as the backseat driver, the backseat firefighter, and she aided and helped the paramedics that were there. It was only when Karen Reed came to talk to her, and she supposedly said, I hit her, I think not once, not twice, but 4 times. So I think Attorney Jackson had to go there to try to show some type of bias, some type of connection between Ms. McLaughlin and the Albert family. That's
was he successful?
Well, let Mike.
I'll disagree. I'll disagree with my good friend Neil. I think, we teach that cross-examination doesn't have to be cross. Right? You want to get information from the witness, and you want to do it in a way that will resonate with the jury. I think, and we've seen too many times, and that's why I said I think we're trying the same case as last time, but this is very, very different, that I think you have to be careful that the jury doesn't start to sympathize with the first responders who were treating just as badly as everyone else and start to feel that they're going too far. You can make your case for reasonable doubt without exploring the very details of these folks' personal lives that every juror wouldn't want to be subject.
No, I personally feel like we've approached that line, if not crossed it. What about the fact that we heard Judge Cannoni deny a request to approach, which for me, you guys tell me, how common is that? This is the first time I've heard it, at least in this trial.
And it was a firm no.
It was
but
a firm, quick no.
She did that right after a sidebar. So my guess is that they had already discussed the elements of the legal issue at the sidebar, and then when he went back and he wanted to start again, and she knew where he was going, so she just denied him right then and there, setting the tone.
And I think that's right. And I think she's had enough. I think she's saying, okay, listen, all of these exams are dragging on too long. She probably reads it as not as effective as you're thinking, and trying to nudge him to move it a little faster, and probably be more effective if these exams were cut by at least about a third. She likely said, we're not going to go all the way to you want to go. Keep it focused. He decided to move out of focus again, and she said, no, we're not doing this anymore.
Neil, will you join us again?
Sure.
All right. Put him on the spot. Thank you, Neil. Thank you. Michael, I know you're sticking around.
Okay.
Right? Yeah, okay.
Still ahead, everyone's entitled to an opinion, but that doesn't mean they're always there's always a need to comment. Up next, the defense catching a bit of flack from the judge for more than one response to testimony. A closer look in just minutes.
You know what? Before we go to break, though, we want to take a moment to remember John O'Keefe, the Boston police officer, the victim in this case. The Braintree native was a father figure and stepped up to look after his niece and nephew after that unimaginable family tragedy. Canton Confidential, the Karen Reed murder trial. We'll be back right after this.
Don't miss any of the Karen Reed murder trial. Get the full recap of what happened in court, expert analysis, and what we could see next. This is coverage you won't see anywhere else. Canton Confidential, weeknights at 7 on NBC 10 Boston.
Michael Proctor, you know that name.
I do.
Who's Michael Proctor?
He was one of the troopers assigned to investigate the case.
As a matter of fact, he was the lead investigator for the case, correct?
I don't know if he was lead or trooper mechanic. I don't know.
As you sit here, you don't know that Michael Proctor was the lead case agent for...
I know he was one of them, yes.
Okay. Do you know that he was the lead investigator assigned to the case?
I don't. I had nothing to do with the DA's office.
Karen Reed's defense team continues to spar with prosecution witnesses about details in their testimonies. We've been seeing this since the trial started. Sue O'Connell is here, our courtroom insider. Sue, we were talking that it can get a little tedious as Alan Jackson is trying to hammer home these differences in testimony. Sometimes it's one word or two words. But in the courtroom, what does it feel like?
So it feels like at some point somebody has to give up and surrender, and neither one of them do. And it happens on both sides, but mostly on the cross right now because this is the defense's turn to do cross-examination. When a witness and the defense are arguing about whether or not the definition of accompanied means that you went to pick the person up and brought them, or if you were there and they were there. Or document, does that mean that you put the drone in the sky, or if you did this? It's tedious, and it's fighting, and it's going on. And you could just, again, 5 of these jurors never look up. They just sit and take notes the rest of the time, and they're a very tough jury to read because they're all very stoic. But we can feel can we just move along? Do we even care about this? Which is the part which I think either loses attention on one side, or if you're trying to evade, it builds it up. So either way, it's not a good look for someone.
So here's the question, Michael. Is Judge Cannoni also losing patience with this? Because, of course, she has the ability to move it along.
I think so. I think she's been an incredibly patient judge throughout both the first and this trial. But I do think she wants to get this case finished, get it to the jury, and get a verdict. And I think she believes that they're, at least intentionally, flouting some of her orders and some of the rules to try and get those speeches into the jury that you're talking about, where she says, no, we get to address the jury during opening statements and closing arguments. Beyond that, we shouldn't be making mini speeches before each question and editorializing. And that's what her patients are at an end with. And many, many judges would be as well. That's improper.
To that point, we've seen a number of times in this trial where Judge Cannoni scolds the defense for making comments during a time that is supposed to be only for questions. Here's a couple of examples.
I'm sorry, I'm going to do my best to ask yes or no questions, and then if there's an explanation, Mr. Lally can stand up afterward and have you explain, but this will go more quickly.
No comments, just go ahead and ask a question.
Sure. That is a textbook example, what we've just seen, of witnesses colluding with one another about a subject matter that's under investigation, correct?
I move for an instruction.
All right, jurors, disregard that comment completely. Disregard that question.
Your Honor, may we approach?
Yes.
So in those examples, Unetti and Jackson getting that rebuke from Judge Cannoni. So when you think about this in the courtroom, Sue, and maybe we can think about it as an engine revving. Is she getting to the red line yet?
Oh, I imagine so. I mean, I look at her in a way of like if you are the parent of 9 children and you have been on a summer vacation on a Cape Cod house and school is approaching and you have had it with them. You're no longer feeding them. You're no longer paying attention to them. There definitely is an impatience. But again, you can also see from Judge Cannoni how much she cares about the jury, right? None of this ever comes out at the jury. She always warmly welcomes them. She apologizes to them. If it takes too long, she lets them go, and sends them back to the room. So I think that there's 2 things going on here. And I also think that when it's Brennan's time for cross, if he does the same thing that Jackson's doing, he's going to get the same amount of correction.
So most of us, if we're watching the trial, it's on the live stream. And when Alan Jackson or any of the lawyers walk away from the podium, you can't hear it as well. Take a little listen just so you can get an idea in case you haven't been watching.
You noted the blood or the coagulation of blood in and around that area, correct?
That is correct.
You noted where you believe the drinking glass was, in other words, what location, if there were grid coordinates, where it would be, correct?
Correct.
And you instructed others to transport that important evidence back to Canton PD to have it booked, correct?
That is correct.
Okay, I want to say, though, that even sounded better. I think we actually were able to enhance the audio. If you're watching it, Sue, there were times I had to stop and maybe put it back a little bit and try to hear what Alan Jackson was saying. He's trying to have these moments. It's not registering for me, but you're in a cramped, small courtroom.
Yeah, it's absolutely registering in the courtroom. And I've said to a number of people on the YouTube stream and on social media, it's not a TV show. It's an actual court case. They don't care in the state of Massachusetts whether you can hear it on your YouTube stream as long as the jury and the witness can hear it. So in the courtroom, Alan Jackson moving forward and back, or any of the lawyers doing that, is going to have more of an impact. And even if, we don't have these little mics on in the courtroom, there's microphones throughout the place, and if they move away from them throughout the room, we can't hear them at home.
Just a reminder, it's not about us.
Yeah, as long as they can be heard, they are moving within the courtroom with a purpose. You're approaching a witness or standing closer to the jury box. You want the witness to look at the jury. They're moving with a purpose. They don't care whether all of us at home can fully understand.
This is why we love having Sue in there, because we don't get that from being outside. Yeah. Michael and Sue, thank you so much, as always, for joining us. If you have any questions, remember you can send them to us, Canton Confidential, at NBCUni.com.
And join us every weeknight at 7 on NBC 10 Boston. We'll have a full recap of the latest developments from court, as well as legal analysis. Plus, this week's episodes will be streaming on Peacock. That begins on Sunday. You're watching Canton Confidential, the Karen Reed murder trial.